number 57, Lividini versus Goldstein. Counsel?
Good afternoon, Your Honor. My name is Dan Ratner. I'm from Heidel, Petoni, Murphy, and Bach. May it please the court. I'd like to reserve 2 minutes of rebuttal time if I can. Thank you. I represent Rye Ambulatory Surgery and West Med Medical Group. No party to this medical malpractice action resides in or has a principal place of business in Bronx County where this case was venued, even though plaintiff placed venue in Bronx County on the theory that one of the parties had a principal place of business. That's not the case. Every party resides in or has a principal place of business in Westchester County, which is
I just want to clarify something. The statute actually says principal office, so does not Dr. Goldstein have numerous offices, certainly at least 2 in the Bronx? Is that not correct?
That is correct, and
Okay.
we're making the distinction between a principal office and a place where someone regularly practices or practices some of the time.
Could I ask this, what do you think the purpose of requiring the mailing address and the education law is, rather than just requiring it bureaucratically? Why is it required in the law statutorily?
Well, I suppose for one thing, for service purposes, for process of service, which is different than venue, possibly that. I know that in the education law, you're supposed to list a mailing address, but also you're supposed to post your certificate in every office that you work in. So I'm not sure exactly what the purpose is, but for venue purposes, there's nothing in the statute.
I didn't find any legislative history on it because I was curious about the same issue, but the analogy can be made to other professions where it's done there. Have you thought about that kind of an analogy?
Well, I grant you that Dr. Goldstein should have updated his license. There's no doubt about that.
Well, I'm thinking more about the mailing address and the education law, and that requirement, say, for psychologists or for social workers. There are a number of professional requirements in education law for teachers, lawyers. We're all required to do those things.
Yeah, I honestly don't know, Your Honor, but so I've been focused on the venue statutes, which don't speak to where one regularly practices. They speak to principal office or where one has his or her abode. There's nothing in those statutes that talk about, you can have the...
So again, that's my problem with your argument. So he has at a minimum, 2 offices in the Bronx. One of them is the one he used as a business office, not as a personal address, for his registration to be licensed in the state of New York. So I'm a little unclear why you think you've met your burden, given that he conceded those other offices. The plaintiff then presents documentation about the registration, which was missing from his affidavit, and he doesn't give any real qualitative information or any documentation to establish which office is a principal office.
Well, Judge,
Given, as you say, the registration, by the way, he did update it while this was pending before the appellate division, and again chose the Bronx, so I'm not so sure there's really a mistake on his part.
So Judge, we did try to explain all this. Well, Dr. Goldstein explained this in an affidavit. He said, I practice...
Yes, I read his affidavit. His affidavit says, my principal place of business is Westchester County. It doesn't say what's his principal office, which is my problem, because the statute says principal office.
Well, he does...
And in any event, that's for a court to decide. Obviously, it also requires certain facts.
And I believe that the facts were laid out in the affidavit in which he said that he is in Westchester County 4 days a week. He sees 20 to 25 patients a week in Westchester, and also supervises residents at St. Barnabas. I believe he said 2 afternoons per week. I think that was not simply a conclusory affidavit. It was a detailed affidavit in which he explained the nature of his practice.
Yeah, but obviously something was missing, since it took the plaintiff to point out where he's actually registered. So it does put in question this affidavit, but in any event, he didn't have any documentation for any of that. Those are, of course, statements that benefit his conclusion as he has made it, right? His first statement, my principal place of business, again, not his principal office, principal place of business. And I'm a little bit uncertain how you meet your burden. But let me ask you a different question.
Sure.
Apropos of what Judge Fahey was asking you. Did you challenge the consideration of Dr. Goldstein under the venue statute 503D as having his own business? Did you challenge that?
No, what we argued was we relied on the appellate division case law that holds that where you are being sued in your professional capacity, then the venue should be placed where you have your principal office arising from
So
that.
then, that's fair enough, and that's what I thought, thank you. So then, are we able then to address the question whether or not that line of case law is correct if you've not challenged it there, not challenged it here? Do we have to, in other words, do we have to work from the assumption that, yes, that provision applies, and then make a determination based on that?
Well, far be it for me to tell you what you have to do, but no one has
Well-
challenged that line of cases, if that's what you're asking me, Your
Yes,
Honor.
that
And it
is
makes
what I'm
sense.
asking.
It
Yes.
makes sense. This case arises from his treatment of a patient under his employment by Westchester Medical
Yeah.
Group in Westchester County. So if he's being sued in his professional capacity, it
Well,
makes...
then that's not his principal office, is it? Isn't it West Med and Rye's principal office? His principal office is he has a practice in the Bronx, right?
Well, he wrote an affidavit in which he said he has a practice under the purview of WestMed in Westchester County, and I
Well,
see some
he
patients...
says he sees, right, he sees patients in all of these places, and then the plaintiff puts forward documentation that his license is from an address in the Bronx, which is the St. Barnabas Hospital address, which in his affidavit, he alleges or avers that he is indeed supervising residents 2 days, two clinics, so obviously he has a position of status.
Yeah, I guess I understand that, Your Honor, but what I think, this reliance on where Dr. Goldstein listed his address,
Yes.
there's nothing in there, it just says a mailing address.
No, it doesn't
for
say that.
venue-
Where does this, I've seen the form. The form doesn't say mailing address, or have I missed the form? Have you got a different form?
Well, I guess I was referring to the education law itself, what the...
Well, the education law refers to a change of address, and then you can hyperlink, but the actual form to apply for the registration requests your name, your address, and then it says business or personal. It tells you if you choose the business, that's going to be made public, your phone number, your email. It doesn't say mailing address, and even if it did, when did we get to the point where a principal office is not necessarily your mailing
Well,
address?
I would contrast that with
Yeah.
a situation in which a corporate entity is required to list its principal place of business with the
I think
state of New
the
York.
application says your office.
In this, Dr. Goldstein's situation.
Well,
yeah.
correct me if I'm wrong. Certificate of incorporation application, doesn't it just say your office?
I believe it says principal office, but I guess...
No, I'm asking you.
I guess I'd have to say I'm not exactly sure then. I'm sorry.
Could I try a different tack, a little bit broader question? So take for granted that an important objective for us, and I'm not saying it is, but take for granted for a moment for this, the minimization of litigation of venue, which, maybe is sort of a waste of time. It isn't really about the merits, and we would like to have a rule that minimizes that. What would that rule be? How would we do that?
Well, I think the starting point would be where a physician is sued in his or her professional capacity, that it should be where the principal office is located. I think that the appellate division has spoken on that. I think the Court of Appeals ought to agree. Secondarily, I think that there should be a distinction between a conclusion in an affidavit versus a conclusory affidavit, if you will. In other words, in this case, Dr. Goldstein, he laid out what his practice.
Well,
And I think it's...
let me just ask you this then, to put a sharper point on it. Suppose we had a rule that said, whatever you put on this form, venue's going to be proper there. That would seem to eliminate a lot of back and forth, right?
I suppose that is correct, and I suppose that if the legislature wanted to do something with the venue statutes along those lines, sure. But the legislature has spoken about this, and it has made a distinction between it hasn't even mentioned the issue of where one practices. It's a principal office. And I think that we met our burden on that issue of establishing that Dr. Goldstein's principal office was in Bronx County. I could see that in Westchester County. I could see my time is up.
Thank you, counsel.
Is
Oh,
that
yes,
right?
Judge
Yeah.
Fahey.
Oh, sure.
How would you address what the appellate division refers to as a lack of documentary proof?
Well, that was what I was getting at when I was making a distinction between conclusory and conclusion. I think that a medical doctor who submits a sworn affidavit that lays out in detail the nature of his or her practice, that ought to be good enough. I understand if it was a conclusory affidavit, and then you need to prove,
Yeah, I think it's, these cases sometimes go to the weight of the evidence.
Right.
And the way I read that was that you had offered some proof, but the weight wasn't sufficient to convince them, and that documentary evidence would have helped that.
Right, and I think, if I could just say one more thing, I think Judge Wilson might not like this, but I would say that in that case, it ought to be...
You never know what Judge
a lot of
Wilson's
things
going to
I don't
like, you know? Don't
But I guess
presume
what I would
that.
say is that, at the worst then have a small hearing. Let Dr. Goldstein, if there's a little bit of a credibility issue. But there really wasn't in this case. Your Honor.
Well,
Did you ask in the alternative of, well, no, you won on the menu. so
that was the
menu
problem.
motion, yeah.
Right, we were the respondent. I did hear in response to the argument that was made by opposing counsel.
Thank you,
Your Honor.
counsel.
Thank you.
Counsel?
Thank you, Your Honors. My name is Frank Longo of Gollum & Longo, PLLC in Manhattan. We represent the plaintiff, Raquel Lividini, and this appeal. May it please the court, counsel, I believe that the First Department correctly determined that Dr. Goldstein and the other defendants did not meet their burden in establishing that venue was improperly placed in Bronx County.
So, counsel, is there something he, over here, sorry.
Yes, I'm sorry, Judge.
Is there something he could have said or some evidence he could have introduced to overcome the form? And what would that be if any?
Dr. Goldstein, yes, I believe he could have, first of all, addressed the issue in his affidavit as to why he listed this address in the Bronx as his business address.
And so
He
if
never addressed
and
that at
so if-
all.
So what could he have said that would have then
Well,
allowed
he
him
could
to
have
prevail?
said, said, I forgot to update it. He could have said that, I don't
It's
think
just more
he-
convenient
but
for me
Let
to-
me just say this. I don't
Sure.
think he forgot to update it because as the
I'm
court noted...
asking something completely different. I would like to know what you think, at a minimum, he could have said to controvert the filing, the
He
form.
could have said, first of all, he doesn't really address the issue of how much time or he spends in the Bronx with all of these activities that he admitted performing, the clinics, the office, hundreds of patients he admitted seeing every month in the Bronx. He's the assistant director of the podiatry department, a podiatry residency program at St. Barnabas. As the court, I think, noted earlier, he worked out of WestMed's offices, not out of his own office. His own office was on Bronxdale Avenue in the Bronx, and that's where we served him, and there was no objection.
Well, you're giving me a whole lot of reasons why he didn't. I'm asking you, what could he have put into an affidavit or provided by the way of documentary proof to satisfy you that venue was not proper in the Bronx?
Well, I think one would have been to explain why he used the Bronx address
And so
put
if
it
he
in the
said,
form.
and what would be a good explanation?
I don't know. I don't think there is one.
Well, okay, so then that's not something he could have said.
So
now
he
go
could have
back.
put in patient schedules. He could have put in appointment
Patient
schedules. He
schedules
could
that-
have,
Sorry, that showed what?
that showed how much time he spent in each
And
place.
what amount of time would be sufficient?
A majority of the time.
Okay?
The only reference he makes to that in his affidavit is that 75% of his income is made in Westchester. But, there could be a lot of scenarios where you have a principal office somewhere and make most of your income somewhere else.
So counsel, to follow up on that, if he didn't have this form, but you had all these other things, would venue be proper in the Bronx?
I believe it would be under this.
So you didn't need the form here?
No, we need the form. I think the form is a compelling piece of evidence showing that this is where he affirmatively designated his place of business.
So my question here then, following up, is New York has a very generous venue statute, much more generous in these circumstances than the federal, for example, because the plaintiff can actually venue the case where the plaintiff lives, which is pretty accommodating. And despite that very generous venue statute, we find ourselves in the position of looking at whether or not an address listed on a form is a mailing address or is it a principal office. I mean, given the rules that we have here and the fairly easy way it is to venue something in a convenient spot for the plaintiff, namely where the plaintiff lives, which is fairly unique, why are we going to get into this business? Like, why are we parsing through a form that doesn't really set a firm criteria for what this address is to see if it's the equivalent of one of the ways under our very generous statute you could get venue in the Bronx?
Well, Your Honor, I think that, first of all, I don't believe this is just a form. This is a licensing registration document that you must file with the New York State Department of Education, which you have to swear to and which you have to file and complete accurately in order to practice your profession. So I don't equate this...
Excuse me, but there's no dispute here that that's a good address. He works there, he acknowledges that he works there, but what is it about the form or the regulations that compel it that give it such dispositive effect in this case or any other case?
Well, I don't know that the case law as it's developed in venue has shown that when you affirmatively designate an address with the state, whether it's Department of Motor Vehicles, a corporate address, an address with OCA, you're bound by the address that you put in those registration documents. I think the better rule to follow is, look, if you're going to affirmatively represent where your office is or where you practice in a state document, you should be bound by that. And a lot of this other stuff shouldn't really matter. But on top of that, we showed that he does have substantial contacts.
Well, I think the issue is, sure, he's conceding in his affidavit that he works at St. Barnabas Hospital, right? He supervises at 2 clinics at the hospital. So it is a business address of his, but the statute says a principal office. And so he's arguing that the affidavit otherwise is an attempt to say that my principal office, because I've got several offices, is here. I mean, I think there's a problem, as I've already said with the questions, that he doesn't really talk about an office, just a county, and that's not what the statute says. But put that one aside for a moment. If you're like this practitioner, I assume there are many like this practitioner, you have more than one office. Certainly the statutes recognize that because you've got these other certificates that are supposed to be tied to other offices where you regularly practice. What is magical, let me put it that way, about the application that we should say, other than perhaps as Judge Wilson was suggesting before, that there's some practicality to just saying we'll just say that's your principal office, that avoids all of this. Is there something else that's inherent in the form?
Well, I just think
That would suggest that, of course, you've listed your principal office.
well, because I think when you register your profession with the state, whether it's a corporation or a driver's license, they're expecting you to put the address where you are for that profession or for that business. And the only way to know is by what you affirmatively put down as the applicant.
Shouldn't they
you know,
say
we're
that?
not- we're-
Shouldn't they say that more explicitly? Shouldn't people be on notice that when they provide that address, for what purpose it will be used? Are we
I mean,
just
look,
surmise?
I'm sure it would help, but I think it's kind of self-evident in a way that when you're doing your registrations for your profession, that you put the address accurately where you practice.
In some
I
of the
think as
forms,
the judge noted that...
in some forms, you can put your personal address, your home address.
Right, but I think as the judge noted, the form has, different addresses, what's your business address, and that's part of the problem why Goldstein's affidavit is not, and he's not even here, by the way, arguing today. He, doesn't explain what he meant by it. So I think that makes his affidavit deficient as well, because, he's the only one who really can say what I intended when I filled this out, and he doesn't. He doesn't even talk about it.
Isn't that it seems to me that is the core of the appellate division's decision, which is this is a burden of proof question. The appellate division says he didn't meet his burden of proof here, prima facie proof. It's straightforward, and his weight was insufficient here. And both it wasn't prima facie, so therefore it was also insufficient as to weight. So the only way for us to touch this is we would have to say that as a matter of law, that affidavit would be sufficient to establish venue.
I agree, and I don't think that, with all due respect, you should
In
do
other words,
that.
we could not, we can't engage in a factual evaluation.
And
That's beyond our powers.
And I would just also point out that in situations where, you know, there has been issues over an address and where it was accurate, and one party comes forward with proof, as we did, of a, you know, sworn registration document, as well as other proof, the courts have consistently said, you have to do more than just put in an affidavit that says, I don't live there, or I don't work
Yeah,
there.
but I don't know if what you put in is particularly relevant, because the appellate division pretty much said he didn't meet his burden, period. They're done.
I agree with that, Your
Yeah.
Honor, but I had to address it.
In
but
terms
yes,
of the shifting burdens, it's kind of straightforward legally.
Absolutely.
Are you suggesting, Counselor, that a sworn affidavit is not enough, that we need documentary evidence?
I'm saying that in this situation, it's not enough. In another situation, it's hard to say. I can't say 1,000%, but I think, you know, certainly in situations where you put in a sworn registration document, you have undenied proof of all of these professional activities in the Bronx, you have to do something more than just put
Well,
in an affidavit.
Do you dispute when his averments that 75% of his time and revenue is gained through the work at WestMed in Westchester County?
I have
Do you
no way of knowing.
dispute that?
because-
I mean, that's in the affidavit. Do you dispute that? Did you dispute that? I mean, I know you objected, I understand that.
Right.
And your point was always he has a practice in the Bronx, and this is the form. But I'm asking a different question. Do you dispute these other averments?
I dispute them to the extent that there's no proof behind what he says.
And
that's-
and did you say that? Did you argue
Yes,
that
well,
in the
that was part of my
objection?
argument, that
In the objection?
he didn't meet his burden of proof, and that was part of it. You know, he didn't,
Would his affidavit have met your requirement if he had attached, say, his appointment book or his billing records? Would we even be here arguing this if that had happened? And it supported his allegation?
I'd have to look at it, but that certainly would, I think, go more towards meeting his burden of proof. But you know, we're doing this at a time where we don't have any discovery on any of these issues. So we're working on what we were able to find in our investigation. And, you know, to the point made earlier about, you know, why the Bronx, why not Westchester? I mean, these are different departments, the Bronx and Westchester. One's first, one's second. If there are appellate issues, I mean, a big difference right now is the backlog of cases. If you have an appeal in one department, it's going to be heard a lot sooner than in another. There are also issues that can come up in discovery where one department may have different views than another that may or may not affect the case. So I don't think, you know, there are very valid, legitimate reasons why a party would want to place a case in the first department as opposed to the second. And, you know, I did, quite frankly, when I was going through the briefs last night, I was a little offended by the dissents, the first department's dissent, where they kind of compared this case to Koshak, where, you know, a plaintiff and their lawyer actually conspired to change venue to the Bronx from Staten Island. The plaintiff moved 5 days before. The complaint was filed. The attorney bought the house and financed it for the plaintiff. I mean, to compare what we're doing here to that is really, it's unfair, and I was offended by it. You know,
Let me ask you this. Is there anything in the record that shows sort of over the course, he's obviously been practicing more than 20 years because he indicates that he's been at WestMed for 21. Is there anything in the record that shows over the course of time whether or not the St. Barnabas address has always been the address, or if that has changed over time? Is there anything like that in the record?
There's nothing in the record or in his affidavit that addresses that.
Okay, thank you.
There is proof in the record, though, that since this has happened, he's actually renewed his registration twice, And both times it's, again, listed the Bronx.
Oh, I'm sorry, I only noticed one. There's twice in the
I believe there
record?
was an update, I looked at it last night, he's now, I believe,
Oh,
registered.
I see, but that's the, or is the record. You mean as a public information?
Yes, correct,
Okay,
yes.
Thank you.
Thank you, counsel.
Thank you.
Counsel, your rebuttal?
Yes, just quickly, Your Honor. I believe counsel said when asked, how you would define, principal office, I believe he said where one would spend the majority of his or her time. I think the affidavit clearly lays out that the majority of Dr. Goldstein's time was spent working at West Med facilities in Westchester County.
So he's got several places he practices in Westchester County. Which one's the principal office?
It's the county where, well, it's West Med has its headquarters in one place, but he splits his time between Rye and White
Yeah,
Plains.
so which one is it? Because obviously, you seem to, and I can understand why, you're not arguing it's the hospital in White Plains, because of course he gives no information about that, so it's very hard to draw from this affidavit that he's arguing that would be a principal office. Which one is it?
Well, put it this way, he says he spends 2 full days in White Plains and 1.5 days in Rye. So I guess White Plains is fairly,
So is that how one measures principal office, the number of hours in an office, in a physical office?
well, I think where he sees the most patients, the revenue, those things weigh into it too, not just simply time.
What
I guess.
if, let's say, you had the hearing, what if it turns out that the Bronx practice not only has all these hours and the patients he says he sees and the residents he supervises, or I don't think he said how many residents he supervises, so we don't really know that way, that it turns out that he actually spends many, many, many hours beyond that, to prepare for all of that work in the Bronx and afterwards, whether it's the billing or he has a private practice at the Pavilion, right?
I suppose if this court offers some more guidance to the lower courts, we could have a hearing and resolve all of these issues, and then I would try to argue that there
But
was
see,
an
that's
abuse of discretion, and I
that's
would
in
lose.
part my point. It's your burden, it's his affidavit. He could have said something like, I spend no other time in the Bronx. This is all I do.
And I believe that
I pick up my mail there because it's more convenient, whatever you wanted to say.
Right.
But see what I'm saying? I have a little bit of difficulty with this affidavit because I feel it lacks a certain amount of information that in part becomes more obvious once plaintiff objects and puts forward the form, because that is suggesting at a minimum, might draw more out of it, but at a minimum, that his presentation to government for purposes of his licensure is, I'm based in the Bronx.
maybe part of the problem, Your Honor, was that he was being sued in his individual capacity for professional work he did on behalf of West Med Medical Group as an employee of West Med Medical Group. This case has absolutely nothing to do, as you know, with St. Barnabas Hospital or anything.
No,
that
but
he
it
did.
has to do with his profession as a podiatrist. It's not unrelated, right? And
But my point is that he was sued in his individual capacity as an employee of West Med, treating a West Med patient in Westchester County. So maybe that's why the affidavit focused on the fact that he treats most of his patients as an employee of West Med in Westchester County and didn't go into quite the level of detail that...
True, but
that
of course, the burden is to show why the selection of the Bronx is improper.
Right. And
You can show many, many connections to
Right.
Westchester. I'm not suggesting
And
that is inappropriate,
Right.
but you've got to say why the choice of the Bronx is wrong.
I believe that he did meet that burden.
Thank you.
Thank you.
Thank you.
Thank you, counsel.